We're going to go ahead and get started. Thanks for your patience in the waiting room. My name is Stephanie Haynes. I am the Executive Director of Philadelphia Family Pride. PFP, I use she, her pronouns. PFP is the local group for LGBTQ plus parents, prospective parents, grandparents, and our kids of all ages. We are not happy to be here tonight, but we are glad that we are able to be here tonight together to offer this important resource in the aftermath of the Roe v. Wade, the Dobbs-Jackson decision last week, overturning the Roe v. Wade case. So a couple quick kind of announcements on how this is going to run. I'm going to be the moderator. Hello. We have Rebecca Nyack and Ben Jerner, who are from the Jerner Law Group. We have a long-standing relationship with their law firm. They are both PFP parents, and also Becca is on our board of directors, and they are LGBTQ family law attorneys. And so I'll let them give more background on themselves. So they're going to talk, they're going to answer questions. If you have questions, we have the ones that people pre-submitted, but then we'll also be asking folks, since we have such a large group, to please put your questions in the chat. For folks who would like to ask a question with ASL, we just ask that you do the Zoom raise your hand, which is under reactions, and then we'll spotlight you to ask your question that way if you'd like to do that. Okay, I think that is everything I was going to go over. So I'm going to turn it over now to Becca and Ben. And like I said before, if you do have questions, just put them in the chat and then we'll get to them in a few minutes. Thank you.
Okay, well, thank you. I think Stephanie said it exactly right, that we're not happy to be here tonight, but it is good to come together as a community in a time like this to, be here together and talk about, what happened, what questions we have, what we can do, and to like a collective moment together to really think about going forward and what protections we can do in this legal environment. So I'm Rebecca Nyack. I'm an attorney at Jerner Law. I've been there for about 12 years. My practice mainly consists of adoption and assisted reproduction. So as you have questions tonight, I will be able to answer questions regarding those areas in particular. I'm going to let Ben introduce himself.
There we go. Now I'm unmuted. Hey there, my name is Ben Jerner with Jerner Law Group. We've been around for about, 19 years now, mostly focused on the needs of the LGBTQ community in mostly Pennsylvania and some in New Jersey. My practice is mostly centered on doing estate planning, and I also do a lot of name changes, particularly for trans adults and children.
So first we're going to try to give a background in a nutshell, because we know that people have a lot of questions. And so we're going to try to give background information pretty quickly. I think we all know what Dobbs does. Dobbs overrules Roe and Casey, which held that there was a fundamental right to abortion prior to viability. And now each state may regulate or even ban abortion as they see fit, and this overturns 50 years of precedent and has given concern to how easily the Supreme Court will put aside other substantive due process precedents that have protected the LGBTQ plus community over the last 2 decades. While this focus of this program is on practical steps that we can take to protect LGBTQ plus rights, it's important not to lose sight on the immediate negative impact on pregnant people, particularly those in poor and red states, of the decision now. And we should certainly, as a community, be looking to see what we can do to help pregnant people who are in need of abortions, especially in those states. This is the first time that a constitutional right has ever been removed in history. And so it really has, been very alarming. And I think the sense of alarm that we feel as a community, at least in this moment, we have lost a fundamental right, and we don't know yet what is to come. I want to talk a little bit about why the Roe decision, the overturning of Roe, has such an impact on LGBT rights. So all of these rights, the right to bodily autonomy, to make decisions regarding your personal life and your family, stem from the right of privacy. And Roe was really one of the first of those decisions in 1973. Then not until, and then in 1995, that's when Planned Parenthood of Southeastern Pennsylvania versus Casey essentially reaffirmed Roe, although there was a more restrictive standard of review. And then in 2003, the court held that the previous decision, Bowers, which had restricted or actually criminalized intimate consensual relationships between same-sex adults, was to be overturned. And they used that same right to privacy that was underpinned in Roe to get Lawrence. And then after Lawrence, we had in 2013, Windsor, which struck down Section 3 of the Defense of Marriage Act, holding that marriage was between one man and one woman, again, founded in those same rights. And then again in 2015, Obergefell versus Hodges, which affirmed the fundamental right to marry, all citing to the constitutional right of privacy. And so here we've now removed this fundamental building block in our constitutional law. And so essentially, if you were reading a law school constitutional book, we would throw a whole chapter away or even more. And so really the right to privacy just protects individuals against government intrusion in the most intimate and personal relationships, including sexual activity and who to marry. And until Dobbs, all of these rights had been upheld. So what does Dobbs exactly say about impacting LGBT rights? There's actually, Obergefell is Dobbs cites to Obergefell. I sort of, searched the text, and it's repeated, I think, more than 40 times throughout the case. And the majority says, oh, no, we're only overturning the right to abortion. This has nothing to do with those other rights. However, it also relies on history and tradition. And it says that the court finds the 14th Amendment clearly does not protect the right to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to abortion. No state constitutional provision has recognized such a right. And when you read that, it's very easy to replace the word abortion with same-sex marriage or even same-sex intimate relationships. And you can see how the slippery slope might go, where courts rely on these types of legal principles and cite to other cases that have come before it. Justice Thomas does not even hide his agenda in his concurrence. He says that today, the court's declining to disturb other substantive due processes rights, but he says right out there, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Because substantive due process is, he says, demonstrably erroneous. We have a duty to correct the error established in the precedents. And the dissent sort of agrees, they certainly don't agree where it's going, but they say, if you follow the reasoning of the majority, all these rights could unravel. They say, we hope we're wrong. We hope we're not reading into the future, but you can't undo Roe without affecting all these other building blocks that we have relied on Roe for in our law. So they say, it doesn't help to take the majority at their word, assuming that it's, saying that they're sincere, that it will only affect this and will go no further. They say the significance of today's opinion will be decided in the future, and that the law has a way of evolving, and the court's decision provides no way to distinguish between the right to choose an abortion and a range of other rights. So that's what the decision says. I'm going to turn it over to Ben to talk a little bit about what that means for us, how much we should worry, for lack of a better term, when we should worry, and talk about what some of our colleagues across the country are saying and doing.
Yeah, and that's sort of what has been the question for the last 6 days is, what does this mean? How much should we be worried? The answer is nobody knows for sure, unfortunately. But there's some things to sort of keep in mind. The good news, if there is good news, is that if there is a change, it's going to take some time. If Obergefell would be overturned, it's going to take a year to 2 years for that case to even get to the Supreme Court in all likelihood. The other sort of good news, if there is any, is that there seems to be the feeling that there's not the same kind of political capital for overturning same-sex marriage as there was for overturning Roe. The not so good news is that the composition of the court is likely to remain the same for a long time to come. The other not so good news is, if Obergefell was overturned, the issue is going to be thrown back to the states, kind of like it's happening right now because of Dobbs with abortion. It's going to go back to the states, and we'd go back to sort of the battle days of a patchwork. Marriage would be okay in some places and not in other places, which makes it extremely complicated to move, to travel, to make plans. So what does that mean for Pennsylvanians? And I know that there's folks probably from several different states that are watching. I'm going to kind of focus on Pennsylvania only because it's going to be too much for us to try to cover all the states. But in Pennsylvania, the Pennsylvania Defense of Marriage Act is still on the books. If Obergefell is overturned and that law is still on the books, then Pennsylvania will once again become a state that has a Defense of Marriage Act. What will that mean? Again, we're not sure. We can say with some confidence that existing marriages will not be invalidated if that were to happen. That's Becca's feeling and my feeling and the feeling of the folks who do this from all over the country. That's sort of like the collective thinking on this. And that's based in part on the fact that to our knowledge, there's never been a marriage that, if it was validly entered into, has been then invalidated later. So we are pretty confident that if your marriage is valid when it's entered into, where it's entered into, that it cannot be then undone because of a bad Supreme Court decision. Now, that's not going to help people if marriage equality goes away. Obviously, that's not going to help people who are not yet married. And those folks, would need to be concerned. But given all this uncertainty, and even if your marriage is safe, or is as safe as we think it's going to be, there's still some things that you should be doing, if you haven't done them already, to try to protect yourself. So I'm going to turn it back over to Becca to talk about some of the parentage issues, and then I'll talk a little bit about the estate planning documents that people should get.
Okay, thanks, Ben. Yeah, so part of the news is that some of the things that I'm recommending are not new recommendations. They are things that we have always recommended that people do with regard to confirming parental rights for children conceived with assisted reproductive technologies who are born to married parents where both parents are not also the genetic parent. So being married to someone who gives birth to a child does not, in Pennsylvania, automatically make you a legal parent to that child. We do not have a statute in Pennsylvania saying who is or who is not a parent. Some states have statutes regarding who is a parent to children born via assisted reproductive technology. For example, New Jersey is a state that says if you work with a physician and you consent to the insemination of your spouse, then you are the parent to a child conceived of that marriage. We don't have any statute that says anything like that in Pennsylvania. We don't have any statute at all on this topic. And so where that leaves us is with case law. And case law, as we've seen, unfortunately, can be changed on a dime. That we have precedents that hopefully will stay in place. But what that case law says actually is that you can be a parent by biology, you can be a parent by adoption. The court has enforced formal contracts regarding assisted reproduction. So for example, if you work with a known sperm donor and have a contract drafted before a child is born, Pennsylvania courts have routinely enforced those contracts to say that a donor is a donor and not a parent. And then the marital presumption is in Pennsylvania, I would say at best unreliable. The marital presumption is the idea that a child born to a marriage is the child of both spouses. And that presumption can be rebutted. How can it be rebutted? It could be rebutted as something as simple as a DNA test. Where our law here on this issue in Pennsylvania is that there was a Superior Court case about 2 years ago, and it had to do with the marital presumption. It was a case involving a trans man and their spouse in the dependency context. And the case had to do with whether the trans man had standing to even participate in that case. And the court said, essentially, we'll apply the marital presumption that he's a parent so long as the marriage is intact. So conversely, if the marriage was not intact, then they would not apply it. And the whole case had to do with analyzing whether or not the marriage was intact because they had separated and got back together and separated, and there was some other issues of domestic violence and such in that case. And so what that tells us is that with the case law that we have, the marital presumption will only be applied when the marriage is intact, which means that if there's a separation or even death, it is likely that it would not be applied. Now, many people have questions about the birth certificate. These birth certificates for married couples are issued in the names of both spouses. But birth certificates are only administrative records of what's reported at the time of the birth. For, if a DNA test is taken, it proves that someone's not a parent. Birth certificates can sometimes be modified or amended. They're also just a state administrative record. They don't have the same power or portability as a court order. So for example, if you go to another state, they do not have to recognize a birth certificate as a declaration of parentage. They do have to recognize an adoption decree. And so that is why we always have recommended doing these. I like to call them confirmatory adoptions. So you'll hear me say that term. Legally for spouses, they proceed under the same statute as, they're essentially to the court, they're step-parent adoptions, they proceed under the statute. But because that does not really feel like what we're doing, we're not having a person come in to parent a child that they didn't plan for. We're having a person come in, to confirm parental rights to a child whose conception they planned for with their spouse, and they're just not the genetic parent. Also for co-IVF, we do these adoptions also just to confirm that both parents are legal parents and that there's not an argument to be made for either person that they're not a parent. And then this even becomes more important if there's a known donor, we'll terminate the parental rights, and we'll also provide clarity to the courts that there's not anonymous donor that could potentially assert any parental rights in the future or be construed to have any. So that is an overview of why we do the adoptions. I can, people have questions about the nuts and bolts. I can speak to that a little bit if that comes up in questions, or certainly I'm always happy to have consultations with people who want to move forward with the process.
Thank you so much, Becca and Ben, and our interpreters. That was a lot. Just from a non-lawyer perspective. But thank you. I think that definitely answered some questions that I had, and some of the questions that people had submitted. So we're going to go to the
I think Ben had a little bit to add about estate planning.
Sorry,
I'm just going to just a couple words about estate planning. I'll try to keep it super short because I know people will have lots of questions. No worries. I just wanted to sort of just highlight marriage confers certain rights, but marriage can't do everything. So whether you're married or you're not married, having estate planning documents is really, really important. For instance, even if you're married, if you become incapacitated for some reason, and someone needs to help you take care of your finances, even if you're married, your spouse cannot automatically do that. So it's important to have a document in place, like it's called the General Durable Power of Attorney, that states, okay, if I become incapacitated, I want my spouse or my partner or whoever to take care of my finances for me. Even if your marriage is recognized, having alternates named. What happens if you and your spouse are in a car accident and both of you become incapacitated? Who's going to take care of your finances at that point? So again, whether you are married, whether you're in an unmarried committed relationship, whether you're single, these are just documents that are important to have. And I'm just going to list them real quick. Just give a very quick blurb. There's wills. At a very basic level, a will determines who gets your stuff. And it also can name an executor, which is the person who's going to make sure that your wishes are followed. As I said, general durable powers of attorney, which talk about who's going to take care of your finances if you can't take care of it yourself. There's a variety of healthcare documents that you can sign. We do those as one document. Some attorneys will do them as separate documents. They deal with who can make medical decisions for you if you can't make those medical decisions for yourself. There's living wills where you can talk about end of life decisions if you're at the end of a terminal illness or you're in a persistent vegetative state. There's HIPAA authorizations, which talk about who can get medical information if you're sick. Who can even go to the doctor and say what's happening with that person. A couple other important documents, beneficiary designations. These are primarily for things that don't normally pass through your will. So this would be property like retirement accounts, life insurance policies. Sometimes people don't even think of those as estate planning documents, but those can be really, really important, and making sure that those beneficiary designations are how you want them and that they're correct. And then the last one I'll mention is called a standby guardianship designation, which we have in Pennsylvania. Not every state has this, but if your state does have it, it's a great document to do. It's for folks who have children, who have minor children. And you can, at least in Pennsylvania's document, you can state, look, if my spouse and I become incapacitated, or if one of us dies and the other one's incapacitated, you can name another adult to come in, take care of the child on a temporary basis, just while you're recovering, let's say. And then when you're well, it goes away. So it can sort of rise up and be activated when needed. And then when it's not needed, the person goes away. You can also name in that document the person who, if something happens to, if there's only one parent, if something happens to that parent, or if there's two parents, something happens to both parents and they both die, let's say, it would allow somebody to step in as a temporary guardian while they file the court paperwork that's needed to become a permanent guardian of those children. So I'll leave it there, but there's lots more to say about those documents. Happy to meet with people individually to talk about what might be right for you, if that's something you need to do. But I encourage that people to do these no matter what your marital status is.
Great. Thanks, Ben. Hearing all this actually reminds me, and Becca was around for a lot of this too, or both of you were, of the days before we actually had marriage equality, and the workshops that we held, which were basically all the same things that you're hearing now, was exactly like how people in our community all the things people had to do to protect their relationships and their relationships with their children.
Yeah, I was actually talking about that earlier today, that we used to do this every year, and it seemed that every year, would change in a positive direction, and hopefully we won't be having to do reverse, but we do know how to think about these issues because we've been there before. Right. And we, have come up with the best solutions that we can, given what the law is at any given time.
Right. And as messed up as that is, it's a little bit of a comfort to me. I don't know, in the sense that it's like, we've been here before as a community. We know what we're doing. we can get through this together.
Yeah.
All right. So let's get to the questions. These are I'm going to go first through the questions that were pre-submitted. I did kind of try to group them by topic a little bit. So one of the questions that was submitted was a very specific immigration question about a partner with a green card. And so, Becca, you had mentioned earlier that person should talk to an immigration attorney.
Yeah, and if anyone needs resources, if you need a different type of an attorney, like an immigration attorney, or you are not in Pennsylvania and you need to, or New Jersey, because actually me and Ben are licensed in both states. But if you are outside of that area and you need a competent attorney who is familiar with these issues in your state, we can get you to that person. So definitely feel free to call us, email me. I'm going to put my email in the chat so everybody has it, and I can get you to the right person, even if we're not the right person. And so, for example, we don't practice immigration law. We can't give advice on that particular issue.
Okay. All right.
And I'll put mine in there too.
Thanks. And I think this question has already been answered, but I want to ask it anyway in case I'm missing something. Someone asked if we have already done a second parent adoption, what else can we do to protect our marriage and family? So I think those were mostly the things, Ben, that you were just talking about as far as the standby guardianship and the wills and estate, the power of attorney.
And I'll also add, there may be a couple quick things that you can also do, which is one of the things I'm going to start doing now that we're sort of back to the bad old days is I'm going to start putting in the documents I do for married folks that the document is intended to be effective whether or not the marriage is recognized in the jurisdiction where it's being used, right? Just on the off chance that, 5 years from now, somebody still has the same document in effect and they're traveling to a state that doesn't recognize the marriage, right? So I'm going to start putting that into my documents again. Again, it's the idea is the document is intended to be good and effective, even if the marriage isn't recognized in the state where they're traveling or living.
My stomach hurt, but yes.
I know. And the other thing I would just add is if you move, let's say you get your estate planning documents done in Pennsylvania or wherever it is that you live, and then you move. It was always important to talk to a knowledgeable estate planning attorney in the new state to make sure that those documents still work in the new state. That may become more important than ever if we have this patchwork, right? So just keeping that in mind is if you do your documents, great, but make sure if you do end up moving to get those checked out by somebody who knows what they're talking about in the new state.
Okay. That's actually a good segue into a different question. I'm going to jump ahead to. A couple people asked similar questions. What if we were married in New York and live in Pennsylvania, or if we were married in Pennsylvania but live in Michigan? Does that matter? Should that matter at all to any of these things other than what you were just saying?
You want to take that one, Becca?
Well, so where you were, so right now, because we don't have a federal DOMA, marriages, entered into any state have to be recognized by any other state. The collective thinking on existing marriages is that those will all continue to be recognized. I think, we don't completely know what the future holds in terms of recognition of existing marriages. But, if we went back to a pre-Obergefell world, I imagine that we would be back to where some states, aren't recognizing marriages from other states at the level. But I think it's, we're peeling back many layers, and we're going to have to see what this looks like as it comes and what these challenges look like. I think, my personal opinion is we're going to see, the challenges, for religious exemptions first, as a basis for, essentially discrimination. And then we might see other types of challenges, but we're going to, see how they come.
Can you just remind people who maybe are too young to know about the Defense of Marriage Act and what that means on both the federal and the state level?
Yeah, so the Defense of Marriage Act was actually
not too young, but like who weren't around when that was like in the 90s.
Yeah, because Bill Clinton signed it, so it was that's when it was. And what it said is that the federal government, so it had two parts. One part 2 said no state has to recognize a same-sex marriage entered into in another state. And then part 3 said that at the federal level, marriage was defined as a union between a man and a woman. And so first Part 3 went away, that was Windsor. And then when Obergefell happened, it said, that sort of made Part 2 moot. But that also, we were just looking at it earlier today, Ben and I, it's sad that we were looking at this, but that also has not been formally repealed.
That is a bummer. And then what you were saying earlier is the Pennsylvania DOMA, Defense of Marriage Act, is still in effect too.
Well, it's still on the books.
On the books.
It's
Right.
unconstitutional as we sit here today.
Right.
But it's on the books. So some states, being smart, like if you're in New Jersey, we're very happy for you. They never had anything on their books, but they actually affirmatively passed a law saying that there can be same-sex marriage in New Jersey. And so we not only don't have an affirmative law saying that there can be same-sex marriage in Pennsylvania, but we also still have that old law on the books that was found unconstitutional. So when you're hearing about like these, not even trigger laws in other states regarding abortion, but pre-Roe laws that were never repealed, that's sort of the same concept that we're talking about with regard to these laws that were declared unconstitutional, but were not repealed.
Got it. Okay. So some more questions on marriage. And I think you answered this, but I'll just ask it and answer what I think the answer is, which is somebody asked, is there any advantage or disadvantage to getting legally married prior to the potential overturning of marriage equality? Which it sounds like the answer is yes. If you were going to get married, go ahead and get married before the outside chance that they roll back marriage equality. Is that
certainly if you were going to get married anyway, like if it's on your plans of things to do and you're just saving up or waiting for the right time, doing it sooner rather than later is what we would recommend. But certainly, marriage comes with a whole lot of rights and responsibilities that need to be understood. Right. And people can, if you get married without, you automatically are getting those rights and responsibilities, and certain laws would apply. If you wanted to divorce, there would be support and property division. And so if that's something you're contemplating, you need to fully understand the rights and benefits associated with marriage. And then if you don't like sort of the package deal that the state gives you, people do prenups and can sort of create what they want the financial arrangement to be if they are getting married, if they don't like sort of the default. And we have another law partner, Jen Newman, who does all of our prenup work if anybody is looking to marry and wants to better understand whether a prenuptial agreement is right for them.
Okay. More questions in the marriage field. The person writing the question said, I'm a transgender male that is legally changed to male in all my legal documents. My wife and I are legally married in the state of Pennsylvania since it was legal, and we also have a son that my wife conceived through the use of donor-bank sperm. Oh, this actually is an adoption question. We currently have not done second parent adoption, but other than parental rights for court, what would this protect for the future, especially with same-sex marriage being overturned? And then there's a related question for if same-sex marriage is overturned, what does this mean for a couple where one person is trans, but legally changed the gender they identify and all legal documents as male, would they still be seen as same-sex? So I think those sort of go together.
Yeah, I'll answer the first one and I'll have Ben answer the second one. So regarding the first one of adoption, yes, any person who is not genetically related to their child should do a confirmatory adoption to confirm parental rights. So essentially I sort of say, like, if the person who gave, if the intended parents are not the same people who contributed sperm and eggs and uterus, then there needs to be some other legal step in place to make sure that your rights are fully secure to your child. And I'll let Ben talk about the marriage itself.
Yeah, I mean, that is a super complicated question. Again, I think marriages that are in place now are going to be absolutely fine. I really think that that's the case. The question's going to come at some point, I imagine, where if there's a state whose law says, all right, we're not going to recognize same-sex marriages, The question's then going to be, what is considered same sex? And that's really going to depend on how that state is defining male and female. And it's early days. We just don't know yet. And I think practically speaking, if your documents are in order and you have a gender marker change, and you look like a heterosexual couple, and your documents say that you're a heterosexual couple, you're going to be able to get a marriage license, you're going to be able to get married. The problem could come, particularly in the event of like a divorce or a death, where, maybe the spouse says, well, we didn't really have a real marriage because this person wasn't really male or wasn't really female, right? Or maybe your spouse passes away and the trans person's the survivor, and maybe that person's family who died comes in and says, well, you weren't really married because you were really a same-sex couple. So there's a lot of ifs involved. There's a lot of unknowns involved. I don't know, Becca, do you have anything else to add to that? I think we just don't know at this point. I think in terms of marriages that might happen after the end of a Burgerfell. Is that accurate?
Yeah, I mean, we can sort of look at laws were in different states took different positions on this pre-marriage equality. And so I think we have to wait and see.
But for instance, like in Pennsylvania, there's no law on the books that I'm aware of right now that defines what constitutes a man and what constitutes a woman. Right. So even in Pennsylvania, we don't even know how that would be applied. Wait and see.
Right. So I think this question was already answered, but I'm going to throw it in because it relates here. Do you recommend confirmatory adoptions for parents who are both biological? I assume that means biologically related to the children, but who have changed their gender after birth?
They shouldn't need to, right, Becca?
No, they shouldn't need to. If they're both people who are parenting and one contributed sperm and the other person contributed an egg, and they're both the intended parents, there does not need to be additional legal action.
Okay.
How about, Becca, a situation where there's it's one person's egg and the other person's uterus?
Yeah, so that one we do confirmatory adoptions in that situation because, again, we don't have a law on this in Pennsylvania, although without any other paperwork. And in fact, if you give birth at a hospital, the person who gives birth name goes on the birth certificate. If for an unmarried woman, regardless, for a married couple, both names go on. But there's a legal argument to be made, against either person. Either DNA testing could rebut the gestational parents' rights, or having not delivered a child could be rebut the other's rights. There have been cases where there are documents on file with a fertility clinic and someone has signed something that says that they were an egg donor when that was not the intention, or a gestational carrier when that was not the intention. And then you also have the factor of a sperm, whether it's a known or unknown sperm donor. The adoption makes clear that even though these two people, they have a biological connection to the child, but both are not genetically related, we still do an adoption to make clear that both are parents and that there's not another person who contributed sperm that is a parent. And when I do those, I do them, as joint petitions. I always am clear with the court what's going on. I say gestational parent, genetic parent, and that we're confirming rights of both. So as I move them through the court, I'm clear, I'm not saying that anyone is less of a parent than the other, but that we want to confirm the rights of both.
Related, can anything be done to protect the parental rights of the non-gestational parent after the birth, but before the confirmatory adoption happens? So I think my kids were 3 months old or something like that before our adoption happened.
Yeah, I'm going to let Ben talk about the estate planning documents, but I will say it's not used as much as I feel like people could use it. You could, if you were very, very concerned, you could even do a very simple intended parents agreement. Our courts in Pennsylvania have enforced contracts regarding assisted reproduction. Oftentimes, particularly in the co-IVF situation, fertility clinics ask for an intended parents agreement to confirm that both people are intended parents. Usually I don't see it in other situations, but if you wanted to be very cautious, you could put a document like that in place. I do believe it would be enforced. And I'm going to let Ben talk about the estate planning documents that can be used for that as well.
Yeah, when you have that situation like in between the time of the birth and the time the adoption hearing and the adoption decree are entered, there are some documents you can put in place to sort of make sure that if something happened to the let's say the person who gave birth, that the spouse of that person who gave birth could take care of the child, make decisions for the child, etc. And that goes back to, again, the standby guardianship document that I talked about. The standby guardianship, in that situation, you can name your spouse as a standby guardian. So in the event something happens to you, either you're incapacitated, sick, whatever, it allows your spouse who's not a genetic parent and not yet an adoptive parent to step in and make decisions for the child, including medical decisions, school decisions, whatever needs to happen, and to take care of the child. And I think from my perspective, excuse me, that's sort of the most important document in that in-between time, having that standby guardianship designation.
All right, a couple more questions from the people who pre-submitted them, and then we'll get into the ones in the chat. So I feel like we covered this, but I'm not 100% sure, so I'm going to ask it anyway. What, if anything, can be done for couples who plan on marrying in the future to protect their marriage at the federal level? So I'm wondering, like, lobbying for, clearly being vote, right? Lobbying for some kind of federal law protecting marriage equality. I don't know if there's anything else to add to that, but.
Well, yeah, I think voting both, for state elected offices and federal elected offices is really important, especially in the upcoming election, where our governor is, going to be decided, because a lot of, both abortion rights and the rights that we're talking about for LGBT families are, going to be on the ballot in that respect. But, certainly if you're not married, you could get married, sooner than later to, so that you're captured, under the people who, when we see what they do with existing marriages, if anything, you will be married, because I think there's a consensus that people who have already married and relied on those marriages will have more rights, are more likely to continue to be considered married than people who have not yet been married.
Okay, so now I'm scrolling back in the chat. Sorry, I was trying to keep an eye on the chat too, but it was kind of a lot too many plates spinning. Everybody just can take a deep breath for a second, I guess. I don't know, I need one. All right. Okay, we got that one. Can we start the process of adoption as soon as the child is born? What you were just talking about, you can actually, there's some paperwork you can do before.
Yeah, and actually you can start the adoption process itself before, because there is paperwork that needs to be collected. There are certain clearances, that we need to provide to the court. If you worked with a doctor, we'll want to get an affidavit that I prepare and send to them. Same thing for the cryobank. So we can collect, 90% of what is needed to file before the birth. And then we can, are better prepared to file as close to the birth as possible. We just need a child's name, birth date, and birth certificate, and then we can submit everything to the court. And usually.
Sorry, go ahead, Becca.
Oh, most counties from date of filing to date of hearing, I'm saying 2 to 3 months, in the counties I practice in.
And I was just going to say, giving us, if you're working with our firm, giving us that little bit of time also allows us to get those other estate planning documents in place, so that by the time a person's giving birth, those are already in place and can protect during that interim time. And also just, in the event of like worst case scenario, right? If someone doesn't make it through labor, they've got those documents in place to be able to transfer property to the spouse or to the child. And it can just take care of a lot of things. We can get a lot of that stuff done before a child's even born.
Yeah, sort of like, end of second trimester is a good time to call us, maybe, if you want to be really on it even before, because we can do a lot. Plus, like, when people have a new baby, the last thing you need to be worrying about is going to get your FBI fingerprints done. And so we can just have that.
Just trying to take a shower. You're just trying to find
Exactly.
a shower. Yeah.
That's right.
Okay, so next question was a little bit a different topic. I'll just read the question from the chat. I have a question about the implications of the case on trans bodily rights and parental rights of trans individuals. Thinking of the situation in Texas, are there any signs that one's right to parent as a trans person and or one's right to transition or one's right to affirm and support a young person's transition will be persecuted or rendered illegal by a subsequent case? And then how can trans individuals and caretakers of trans youth best protect them in these times?
I don't know the answer to that. I mean, I don't. Have there been any cases that you're aware of, Becca, at the federal level that have? I don't think there's been at least any appellate court cases that have dealt with the right to make those kinds of decisions for a child, for a trans child.
No, I mean, we've seen what's happened in Texas, and that's really scary. I think that was a lot of questions in one. I think from the custody parenting perspective in terms of rights as a trans parent parenting a child, I think that even prior to for many years that's really been educating the court. I think the courts are more educated than I've ever seen before. That's not said that there's still not work to be done, but a lot of, like, in a custody case, that's going to depend on the individual judge and a lot of their personal biases. But there's been a lot of work. I have been all over the place with judges who and I've been pleasantly surprised for judges honoring people's pronouns, appropriately addressing people, and so I think that education that we've done has been successful, and hopefully we'll continue those efforts to educate the courts. So at least some of these personal biases may not come into play should you find yourself like in a custody dispute in a court.
My concern would be for the parents, like the parents in Texas who are seeking care for their trans kids, how much of that right to parent and right to make decisions for your kid's care is based on that privacy right. I don't know off the top of my head, but that way my concern is that once we start chipping away at privacy, do parents have a leg to stand on when they need to make healthcare decisions for their kids?
Right, because
I don't know the answer. But
yeah, in states we're seeing them take that gender affirming care and liken it to child abuse, which is scary. That even goes beyond privacy. They're saying that they can use the same resources that they use for children who are whose parents rights might be suspended for a period of time because of other issues like child abuse. That they're applying those same standards to this issue, and certainly we've seen that other places, but not here.
It certainly goes to highlight the fact that we need to make sure, I think more and more and more, we're going to have to be depending on state officials to determine what our rights are going to be, right? That law in Texas is a Texas law. It is in place for folks in Texas. We need to make sure that that kind of thing doesn't happen here. In whatever place where you live, you got to do everything you can. We all tend to focus, I think, on federal elections for good reason, but I think more and more it's going to be so much more important that we focus on the state and the local elections, because from the way things are shaking out now, those folks are going to be the ones making the laws that we all have to live with and live under.
And we elect judges in Pennsylvania, so there's also
and we elect judges
elections
in Pennsylvania, right?
Yeah.
Which nobody pays attention to, right? We all have to start paying attention to that stuff and making sure that we elect people who share our values on this stuff, and talk to your friends and your family and your allies and make sure that they are doing the same.
Right.
We can't check out.
No. All right. So I'm just going to thank you for that, both of you. And thanks for the question. I'm just going to keep going through the questions because we still have a few left here. There was another reciprocal IVF question, but I think that was already covered, which is those folks should still do a confirmatory adoption if both intended parents aren't genetically related. Okay. Let's see. Okay, if a transgender parent who transitioned and remained married to their pre-transition spouse and both are the biological parents of their children, should they try to update their children's birth certificates and marriage certificate to change the trans parent's name from their dead name to their authentic name? Is that even possible? I do not know if this has even happened or is possible in New Jersey or Pennsylvania.
I know that we've done that. So you have a married couple, there's a birth certificate, let's say for their children, that's issued with both parents' names, and then one of the parents transitions. Is that the question?
Right. And then should they go back and have their name on their birth certificate, their parental name changed on the birth certificate, and they said marriage certificate too.
Right. So in terms of the child's birth certificate, we have gotten that done. We've been able to get that done in Pennsylvania. I don't know off the top of my head whether it'd be possible. Do you know, Becca, about the marriage certificate? I know I had a case where the folks were married in a different state, and we looked into it at that point to see if we could get the name updated on the marriage certificate in the other state, and it was going to be extremely difficult, if not impossible, to do it there. I'm not sure what the law is in Pennsylvania, because I don't think I've ever had to try to do it in Pennsylvania.
Yeah, I don't.
Dealt with that?
We haven't tried to do it yet, so we could try, but we haven't tried yet. And of course, it would go to whatever county where you got the license from. Right.
All right. Thank you for that question. The next question is for folks who had all the documents that you talked about, power of attorney, will, all that stuff done pre-marriage equality, and this would actually, that my family would fall into this category too. Is there any reason to have those documents updated given the current climate, or would those documents still be appropriate if the people's names are the same, then all the relationships are the same?
Well, even aside from the stuff we've been talking about, there's actually been some changes in Pennsylvania law that impact on estate planning documents, dealing with things like digital assets and things like there's been changes, the law changes. So I typically recommend that everybody look at their documents every 2 years. And if there's been any sort of major change in their family or in their financial situation, get them updated. If you're not sure if you need to update them, have an attorney look at them and just make sure that they are still appropriate, that they're still the best documents that in terms of what your needs are at that time. So I don't think it's necessarily true that somebody has to update them if they're that old, but if they are that old, it's probably time to at least have a lawyer look at them to make sure.
Okay. I'll put that on my to-do list right now.
Yes, you better.
So this I feel like we covered. Would getting married before your legal name change keep you from changing or renewing your name on the marriage document in the future? It sounds like if you had a choice between the order of things you could do, it sounds like you'd want to do your name change first and then get married if you were able to do that. Is that accurate to what you were saying before?
I think that's right.
Yeah. Mm-hmm. Is it best to get remarried in Pennsylvania if you were married in another state?
The marriage should be recognized in Pennsylvania, so I don't see a reason to do that, and to get remarried could confuse the date of the marriage, which can cause problems if there was ever a divorce or separation. So I would say there's not a reason to do that. I'm
not even sure that there's a mechanism in Pennsylvania. I know there is in New Jersey, but I'm not even sure in Pennsylvania. Can you even get remarried in Pennsylvania without getting a divorce first?
I mean, you probably could without disclosing that you were married to each other already, right. But I don't think like that's what they, that wouldn't be an appropriate, thing to do, not disclosing that prior marriage.
Yeah.
So another question sort of related that we haven't talked about is what impact this would have on divorce rights. So,
Yeah.
I mean, this was an issue I know in Vermont for couples who got married in Vermont, but then couldn't divorce. They had to like move to Vermont to get divorced or whatever pre-marriage equality. So,
yeah, we did that. That would be, I mean, we had those things. They were called, we called it wedlocked. People were wedlocked. They were in marriages that they didn't want to be in, couldn't get divorced for a period of years because Pennsylvania courts wouldn't recognize them. And we had to come up with different creative solutions. Sometimes people moved to New Jersey. It was terrible. I think that there would absolutely have to be a mechanism to allow people to be divorced given all the existing marriages already. I can't see that even if they said marriage was no longer, same-sex marriage was no longer legal, I don't see how they could not have a solution in every state for people who no longer wanted to be in those marriages.
And that, again, that goes back to, we believe that they're going to recognize the marriages that exist as of that time.
right.
Divorce is just another benefit, if you will, of being married, right? So if they're going to recognize your marriage, they're going to let you get divorced.
Okay. Let's see. All right, another marriage certificate question. We'll pass by that. I understand that voting is a huge component here, but I'm wondering more if there are additional legal documents that can be done to protect things on a federal level. So everything we've been I get the question now. Thank you for restating it. All the things we've been talking about are all the things we can do in Pennsylvania. And the question is there anything we can do as individuals, federal documents? And can I pretend like I'm a lawyer and answer this question? Because I think I know the answer.
Okay. Go.
Marriage is a state law. Marriage is state law, so they couldn't do it on federal level.
Yes.
Is that right?
Yeah, that's correct. That all the rights and benefits flowing from at least entering into it are there. The federal government will recognize it for like things like taxes or Social Security, but they recognize it oftentimes based on what state law is. So Social Security looks to the law of your state. I've done like a lot of these common law marriage cases for people who were in long-term relationships prior to 2005. Just that's what Pennsylvania law says. And we've been able to establish common law marriages for purposes of Social Security, but you can't do that in every state. You can do it in Pennsylvania because we common law marriage up till 2005. So yeah, so the federal benefits flow from the state law.
Right. And so that was actually another person's question after the divorce question, which was, would you, like, if your state stopped recognizing your marriage, which it doesn't sound like you think that would happen, you would then have to change like how you file your taxes federally. Because I mean, I remember because my wife and I were together, and really when we got married, it was so that we could file our taxes together. It was like, it was very romantic. But
yeah,
that was sort of the reason we got married when we did, was literally like December 30th, so that we could like, file our taxes together for the next year.
Yeah, I mean, and that there again, there was like this patchwork before, because the federal government, only recognized marriages after Windsor, for tax benefits. And so, we'd be back to that world where if you had a marriage and the federal government didn't have a DOMA that said that marriage is between one man and one woman, you should be able to file your taxes jointly.
I'll just put a little plug in terms of updating, just on the question of like, is there anything we should do federally now?
Mm-hmm.
I do think it makes sense while we have a friendly administration in place. If you are trans and you want to update your federal documents in terms of like gender marker and things like that, things are about as good as it can be right now. Like they could, a different administration could make it much more difficult to change things like gender markers. So I always like to use these windows of time when we have friendly administrations to get that kind of stuff done if you're going to do it, if you care about doing that.
Or I like to update your passport, for instance. Or
update the gender marker on your passport, update your Social Security. Yeah.
Okay. I just want to note that we're at 9 o'clock. There are still lots of questions. So if Ben and Becca, you all are able to stay on a few more minutes, we'll keep rolling with the
Yeah, we
questions.
can go a little
Okay.
bit longer.
What kind of documents could go into a safe folder to push back against harassing CPS investigations if that starts to happen in PA, Child Protective Services? I assume that means.
I assume that means regarding trans affirming care for a child.
They didn't specify, but.
Yeah, I mean, I think, well, if that, what happens in other states were to happen here, I don't know that there's anything that could go in a file like that. I think, in that world, I know in the states like tech, that people have considered moving to a place where they will not be faced with that type of scrutiny.
I'm just going to roll into the next one. Can a couple create financial safeties for investments, insurance, property, et cetera, before getting married if they would like to protect their shared interests but haven't made a legal partnership?
I'm sorry. Can you say that the cohabitation agreement? I need to go back.
Yeah, can a couple create financial safeties for investments, insurance, property, et cetera, before getting married if they would like to protect their shared interests but haven't made a legal partnership?
Yeah, certainly, because we did that before marriage equality. We've done it after for people who don't want to marry but want to, make sure that they understand how their jointly acquired property will be shared or inherited. And so we can, do a variety of things both through estate planning and through cohabitation agreements.
This is related to the earlier questions on rights for trans folks. What are the options for a person who is unable to change their gender marker on their birth certificate? My husband was born in Texas and has run into issues.
It's a good question. It's not real clear to me what impact the gender marker on a birth certificate has. There are some folks who just literally can never get the gender marker changed. Does that mean you're not a man? Does it mean you're not a woman? It's sort of the Wild West right now, and it has been for a while. Particularly, like I said, in Pennsylvania, there's no definition that says, there's no law in Pennsylvania that says you are what's on your birth certificate. That might exist in other places. You remember, was it the North Carolina bathroom laws that they would look to the birth certificate? Like that could be a problem in places like that. If you're in Pennsylvania, there's no law that says that, anybody's going to look at your birth certificate to determine your gender. So the answer is, it's just not clear at this point. And for good or for ill, we don't have a law in Pennsylvania that says you're a man if, you're a woman if.
Got it. Someone I think wanted clarity on a question that we asked earlier is if somebody was married out of state before Windsor, should they get, quote, remarried in Pennsylvania?
Yeah, and the answer is no at this point. There's no need to do that, and it could cause confusion.
Yeah. Yes, this recording will be available. We'll put it on our YouTube channel, so that I'll answer that question real quick. In the state of New Jersey, can you go through the legal parentage process on your own, or do you need to have an attorney?
It's not required, in Pennsylvania, New Jersey, or any other state that you have an attorney to move you through the process. Many people choose to work with an attorney because, we could streamline it for you. We know what to submit. We do it all the time. But there's not any legal requirement that it be done with an attorney.
This is more of a tax question, but our federal tax was reduced when we filed jointly. That's why we want to know if our filing status is affected by state recognition, higher taxes, among other things. Yikes.
Yeah, that happens for a lot of people. And I know some people have done creative planning. I've even seen some people get divorced and get civil unions to avoid higher taxes. And New Jersey still offers civil unions. But that's not necessarily a great solution if you don't live in New Jersey.
Yeah, I mean, for some people, your taxes can go up if you're married. For others, they don't. I will also say that in terms of things like inheritance taxes, Pennsylvania has an inheritance tax. If you leave property to somebody who's your spouse, you pay 0% inheritance tax in Pennsylvania. But if you leave property to somebody who is your partner, your longtime partner, you will pay 15%, 1-5.
And that's even for things like a jointly titled house. We saw this a lot in those common law marriage cases where people, have been together for 50 years and not gotten a legal marriage. Many times they're filing seeking recognition because of the inheritance tax, because they're going to have to pay tens of thousands of dollars on a house that they have owned with their, common law spouse for decades, and they're having to pay tax on half of the value.
It wasn't that the Windsor decision was about that. Sorry to interrupt.
Yeah,
that was about federal estate taxes, but it's the same idea. It's the same thing. I mean, hardly anybody pays federal estate taxes anymore, but yeah, for federal estate tax purposes too, if you have that much money, over $12.5 million, whatever it is,
no.
Federal estate tax, right? I'd like to have that problem. But for federal estate tax purposes, your spouse pays zero. Anybody that's not a spouse pays a lot more than that. So, but just on the marriage question, if taxes are entering into your thought process about whether to get married or not, definitely think about income taxes. But don't forget, if your state has some sort of a death tax, like an inheritance tax, make sure you consider that as well.
Okay. I have one more question, and I was debating about asking it, but I'm just asking all the questions. So without succumbing to hyperbole, at what point should we consider leaving the US? What are the legal protections that once gone or overturned make this country no longer safe for queer people and our families? What is the tipping point? And I'll actually say, let's talk about that. And then let's try to end on a more positive note, which would be like, what are the reasons that we shouldn't need to, I mean, maybe that's how you're going to answer it, but.
Yeah, well, I think that's a personal decision for each person. They have to make that calculation themselves. We said we've seen, where we've come from, that could, people's, but there's been shifts, so even if our court goes backwards, that doesn't mean that people's minds go backwards. That doesn't mean that things won't go forwards again. But at any moment in time, everybody needs to make that calculation for themselves. What, how does that balance with, what family support you have locally, things like that. And so, there's not a one size fits all answer to that question.
All right. So
you want something happy now? You want
something happy, and then I can talk about a little bit about what's next, Philly Family Pride style, for folks who are still on, who want to know about our next events and things. I can talk about that too.
I'll say something happy, happy-ish, which is I've been so impressed. I'm on different listservs of attorneys all over the country who do this stuff. And I have never seen people who are so committed, who care so much, who are so smart. These are some of the smartest people I've ever met, who are working their butts off to do everything they can to try to figure out what's going on and figure out what's going to happen, figure out how to help people, give people advice, kind of like we're doing tonight. Just they're really working hard to try to figure this stuff out, and that gives me some hope. We've got a lot of smart people on our side on this thing, and there's a lot of people just in terms of the general public that are supportive of our rights. So I think that feels different to me than 15 years ago, and I think that is definitely a bright spot.
Great. Well, I think that's a great place to end. Thank you, everybody, for being here. Thanks to Rebecca and Benjamin for their expertise in answering all the questions. And thank you to our ASL interpreters for their hard work. I'm not going to end the meeting because I always feel like that's like slamming the door in people's faces, but I will stay on a bit if people want to hang out and chat for 5 or 10 more minutes. But otherwise, thank you, and hope everyone has a nice evening.
Yeah, thank you. And look at
Thanks,
Philadelphia
everyone.
Family Pride's events
Oh, right.
page.
Yes. Thank you. Sorry, I was going to plug that. Yes. So thank you, board member Becca, for reminding me. We have lots of stuff posted on philadelphiafamilypride.org. Phoebe, our awesome intern, also put something in the chat earlier. She's actually been organizing our Paths to Parenthood classes, which will be starting very soon, next week, which will cover all the typical things that we cover: adoption options, becoming a foster parent, demystifying surrogacy. There'll actually be a session with Becca on asking your family formation legal questions. I think a lot of the answers will be the same as they were tonight. And then we have other just meetups in the park and other fun sort of just social things happening. So
Yeah.
be sure to check out our events.
And as the last thing, I know that sometimes it can feel intimidating to call like an attorney's office, but definitely feel free to use us. Our law firm was founded to serve the LGBT community, and we definitely want to be a resource for everyone. For my type of consultations, I don't charge for that. If you want to individually know what you need to do regarding confirming parental rights, just give me a call. I have a 15-minute conversation with you to go over exactly what you need to do and give you more of a nuts and bolts idea. So thank you all for being here. It was really, nice to see so many names and faces that I know. And for those of you who I don't know, we hope to meet you in the future.
And thanks, Stephanie, for putting this on. It was
Sure.
It was great. Thank you.
Thank you. Thank you all.